Good afternoon. Thank you for joining us today for our second day of Dentons Ontario Employment and Labour Fall Webinar Series. I'm Ebejer, partner in our Toronto office in the Labour, Employment, Immigration, and Pensions Group. My practice involves advising clients in all aspects of employment, labor, and pension and benefits law. Additionally, I represent employers in civil actions and grievance arbitrations and before administrative tribunals such as the Ontario Labour Relations Board and the Human Rights Tribunal. Today, I'm joined by my esteemed colleagues, Allison Buchanan and Claire Browne. Allison is a senior associate in our Toronto office. She has experience in all areas of employment law and routinely provides strategic advice on challenging employer issues such as employment standards, employment contracts, human rights and accommodation, harassment and discrimination, executive compensation structures, employee benefit plans, and workplace safety and insurance matters. Additionally, she advises and represents her clients in employment-related litigation and human rights complaints. Claire is an associate in our Toronto office. Claire advises private and public sector clients in all areas of labor, employment, occupational health and safety, and pension and benefits law. Additionally, Claire represents employers in wrongful dismissal civil actions, occupational health and safety matters, and proceedings before the Ontario Labour Relations Board. Today's webinar will include topics such as unique compensation issues, updates to employer policy requirements, and updates in occupational health and safety law. With that in mind, I will kick things off discussing unique compensation issues, and in particular discussing compensation issues that can arise at the time of termination and thereafter. Next slide, please. Going back to first principles, an employer in Ontario is entitled to terminate an employee's employment without cause by providing common law reasonable notice. The notice can be provided by way of working notice, pay in lieu, or a combination thereof. But where pay in lieu is provided, the employer must make the employee whole for the entire notice period. And so this means that the employer must provide all forms of compensation, incentive pay, and benefits such as disability benefits, life insurance, that the employee received for the entire notice period. In Ontario, the Employment Standards Act provides a floor of right to employees. Upon termination without cause, the ESA requires the employer to continue the participation of the dismissed employee in all benefits plan in which they were enrolled in at the time of termination. And this is to continue for the entire statutory notice period. More broadly, the employer under the ESA has an obligation to maintain all terms and conditions of employment through to the end of the statutory notice period. It's not uncommon to see an employer dismiss an employee without working notice and provide pay in lieu of notice, and in doing so, the employer will end the employee's benefits coverage on the last date of the statutory notice period. Usually this is fine and there won't be any issues. But are there any risks with this common practice? What happens if a former employee becomes totally disabled during the common law notice period? In this case, would the employer be liable for employees' disability benefits coverage? Next slide, please. The short answer is yes. A recent case of PASOP from Saskatchewan is a stark reminder of the magnitude of the risk to an employer when benefits such as long-term disability are not continued for the entire notice period. In PASOP, the court found that the terminated employee was entitled to 8 months reasonable notice. 2 months after the employee's termination, the employee, who was only 38 years old at the time, suffered a serious medical incident, which a judge found made the employee disabled for the rest of his working life. The employer didn't continue the employee's participation in LTD throughout the entire notice period. At trial, the employee sought entitlement to loss of disability benefits pursuant to the insurance policy. Now, it's important to know that this policy was owned and administered by the insurance company, and this was not the case where the employer was self-insured with respect to LTD. Applying the insurance policy, the court found that the employee was totally disabled and entitled to long-term disability benefits. As the remedy for loss of disability benefits, the court had the employer step into the shoes of the insurer. There wasn't the option of putting the employee back onto an LTD claim, as this wasn't the case where the insurance company was part of the litigation, and also wasn't the case where the employee had made a claim for LTD and LTD had been denied. So this meant the employee was liable for 26 years of LTD benefit payments, that is the payments of the benefits themselves, not just the premium, from the date of total disability, so when the employee was 39 years old at the time, up until the date that the employee turns 65 years old. Next slide, please. And while PASAP was a case from Saskatchewan, it is entirely consistent with Ontario law. The Ontario Court of Appeal in Connaught Kitchens confirmed that an employer can be liable to pay LTD benefits to an employee. The employee in Connaught Kitchens was 55 years old with 24 years of service. Sorry, I think my lights went out. Okay, there we go. We're back in business. And he was paid, he was 55 years old with 24 years of service when his employment was terminated without cause and without working notice. He was paid only his minimum statutory entitlements, and his LTD coverage was terminated at the end of the 8-week statutory notice period. The trial judge found that the employee was entitled to common law reasonable notice of 22 months. 16 months after termination, the employee was diagnosed with cancer, for which he received treatment, and thereafter he wasn't able to work. Although the employee secured employment 2 weeks into the notice period, the alternative employment did not provide disability benefits. And so at trial, the employee was seeking damages for lost disability benefits. Similar to the judge in PASAP, the Court of Appeal here deemed the employer to step into the shoes of the insurer and ordered the employer to pay the employee the LTD benefits that the employee would have received under the policy until age 65. Next slide, please. There are ways to address and manage this massive risk. From a proactive perspective, before employment commences, ensure employees sign employment agreements that have enforceable termination provisions. The enforceable termination provisions should, among other things, limit the continuation of benefits, including disability benefits, to only the requirements of the applicable minimum employment standards legislation, or perhaps some other period that the employer is comfortable that it can continue benefits coverage. It's important to remember that in PASAP and Connaught Kitchens, the liability arose because the employee was entitled to common law reasonable notice, and the employees in these cases were not employed pursuant to enforceable termination provisions limiting that right. Another step to take is discussing with your insurer options to continue disability benefits post-termination. Perhaps this is a discussion at the outset when you're setting up the plan, or perhaps a discussion on a case-by-case basis when there's about to be a termination of an employee's employment. Upon termination, the employer should obtain an enforceable full and final release, and that full and final release should, among other things, release the employer from any liability for loss of disability benefits. The release is all the more critical if your insurer will not extend LTD coverage over the notice period and the departing employee doesn't have an enforceable termination clause. Offering common law reasonable notice, in this case, could also assist in getting that release. And so where an insurer refuses to continue benefits coverage for the entire notice period, you should consider perhaps providing compensation in lieu of benefits coverage and perhaps rolling that into a termination package. And as well, it could also assist in getting that release. And finally, you may wish to consider arranging for alternate disability coverage with another insurer for the reasonable notice period if your current insurer refuses to do so. And I really raise this option because the Court of Appeals critical statements of the employer in Connaught Kitchens. And the Court of Appeal was quite critical of the employer for not making any efforts to look into alternative arrangements to provide their long service employee with replacement disability coverage. Next slide, please. In any discussion about compensation issues in the context of termination, I would be remiss to not give an update on the law after the Supreme Court of Canada's decision in Matthews and Ocean Nutrition. And so just as a reminder, Matthews was a case that considered whether a dismissed employee was entitled to payment under a long-term incentive plan, despite no longer being employed. The court started off with the principle that unless otherwise lawfully limited by contract, employees are entitled to common law reasonable notice upon termination. Where pay in lieu of notice is provided, all compensation and benefits the employee would have earned during the notice period is to be provided or continued. The case had confirmed a two-part test for determining whether an employee is entitled to a bonus payment upon termination. The first part of the test asks, would the employee have been entitled to the bonus or the benefit as part of their compensation during the reasonable notice period? And if so, do the terms of the employment contract or the plan unambiguously take away or limit that common law right? In Matthews, the court answered the first question in the affirmative, and then the court turned to whether there was any language in the bonus plan to remove the employee's right to payment. And so looking at the termination provisions of the plan in Matthews, the court had the following comments. While there was a requirement to be a full-time or active employee in order to receive a bonus payment, this wasn't sufficient to remove the employee's right to the entitlement to a bonus payment during the notice period. Had the employee received working notice or been employed until the end of the notice period, that employee would have been a full-time employee or active employee. The termination provision must address the specific circumstances that have arisen. And so you'll see that the termination provision indicates that it applies where there's a termination with or without cause. And so the court concluded that this didn't apply because the employee in Matthews had been constructively dismissed, which isn't a termination with or without cause, it's an unlawful termination. The termination provision stated that the bonus would not be calculated as part of any severance payment. This too was not sufficient. The court distinguished between a employee receiving a bonus payment and an employee seeking damages for loss of a bonus payment, the latter of which the employee in Matthews was seeking. And finally, the language that in the termination provision that the bonus had no current or future value other than at the date of a triggering event is also not sufficient, because if the employee had received proper working notice, he would have been paid his bonus as a triggering event actually took place during the notice period. Next page, please. So where are we now? The recent case of Rural and Air Canada showcased the application of the Matthews principles. The employee in this case was 52 years old with 25 years of service. In addition to a base salary, his compensation included various forms of bonuses, a defined benefit pension, group employee benefits, post-retirement benefits, and flight privileges that included lifetime business class tickets for him and his wife. Upon termination, the employee sought damages for reasonable notice that included salary, bonus, pension, group benefits, and the flight privileges. The court found that the employee was entitled to 24 months of service, and then the court turned to determine whether the employee would also be entitled for the loss of the various benefits, bonuses, pension, and other employment privileges, such as the flight privileges. And here's where we saw Matthews in action. So with respect to the bonuses, the judge found that the plan's language did not unambiguously take away the employee's common law entitlements. The termination language had conditions of active employment and performing duties on the payout date. And the court reiterated the principles in Matthews that had the employee been given working notice, he would have been actively employed or performing his duties. The employment contract isn't considered terminated or at an end until after the end of the reasonable notice period. With respect to the loss of pension benefits that would have accrued had the employee worked until the end of the notice period, the court applied the principles in Matthews to the pension plan and found that there is no provision in the plan that unambiguously states that an employee is not entitled to pension accrual during the common law notice period or not entitled to damages for the loss of pension benefits that would have accrued had the employee worked until the end of the notice period. And so you'll see that while the definition of termination of employment is tethered to the definition of continuous service, the court found that each of these provisions did not indicate that an employee upon termination without reasonable notice is not entitled to continuous participation in the pension plan or damages for loss of that opportunity to have pension benefits accrued for the entire common law notice period. One unique aspect in this case was the award of reinstating the employee into the flight privilege program for the rest of his life. This is particularly unique because normally a court will award monetary compensation for loss of an employment benefit. However, the court thought that it would be fair to reinstate the employee into the program as opposed to paying a lump sum payment because the program had language that it could be modified or discontinued at any time. And if such modification or cancellation should occur, it was possible that any lump sum payment for the value of the flight privileges would become inaccurate. Next slide, please. And so Matthews and Air Canada confirmed that employees are to be awarded everything they would have been entitled to had they actually worked through the notice period, unless there is contractual language that unambiguously and clearly states otherwise. And so these two cases are a good reminder that employers should ensure they have effective language in employment agreements, incentive plans, and benefit plans that address these types of entitlements upon termination. And in terms of practical drafting tips, the provision should indicate clearly when an employee becomes entitled to a bonus and remove the right to a bonus or incentive payment upon the end of employment. Indicate that there's no entitlement to a bonus until it's calculated and paid, and state that a dismissed employee cannot participate in the incentive or benefit plan during the reasonable notice period, and state that a dismissed employee is not entitled to damages for the loss of incentive pay or other benefits over the reasonable notice period. Now, remember that there are the requirements of the Ontario ESA, which are to maintain all terms and conditions of employment until the end of the statutory notice period. And so while you can certainly contract out of an employee's common law entitlements to incentive pay and benefits, one could not do so and actually would run afoul of the ESA if there was an attempt to limit those entitlements during the statutory notice period. And that about wraps up for me. I will turn it over to Allison.
Sorry, I was not unmuted there. I was just saying, thanks, Pam. That was a great reminder of why we need to have enforceable written employment agreements in place for all of our employees. It's a great way to limit liability. So good afternoon, everyone. My name is Allison Buchanan, and I'm going to be talking about two new mandatory policies for qualifying in Ontario employers. The first is on disconnecting from work, and the second is on electronic monitoring of employees. Next slide, please. Next slide, please. So the first about disconnecting from work. Many other jurisdictions, such as France and Spain, Scotland, and Italy, have all introduced a right to disconnect in some form or another. In Canada, however, only Ontario has passed a law requiring employers to have a disconnecting from work policy. Bill 27, which was the Working for Workers Act 2021, amended the ESA, the Employment Standards Act, to require provincially regulated Ontario employers with 25 or more employees to have a written policy in place with respect to disconnecting from work. And that had to be in place by June 2nd of this year. Further, all employees must be provided with a copy of the policy within 30 calendar days of the policy being prepared or changed, and new employees must receive a copy within 30 calendar days of being hired. However, please note that if the policy is in place and nothing has changed year over year, there's no obligation to provide employees with a new version of the policy if nothing has changed. And the employer can satisfy this obligation of providing the policy to its employees by providing them a printed copy. It can also be an attachment to an email if the employee has access to a printer, or a link to the document online if the employee has an opportunity to access it via the internet and also has access to a printer. Next slide, please. So what does the policy have to say? There's been quite a bit of criticism about the policy requirements because at this point they're relatively vague and quite aspirational, actually. Qualifying employers are simply required to implement a policy addressing the topic of disconnecting from work. Employers have been provided with little detail about their substantive obligations relating to the policy, including having little direction on the content of the policy or its length. That said, we can look to the definition for some guidance. And the term disconnecting from work under the ESA is defined as, quote, not engaging in work-related communications, including emails, telephone calls, video calls, or the sending or receiving of other messages so as to be free from the performance of work. End quote. Further, Ontario's Ministry of Labour released guidance on Bill 27 via its guide to the ESA. The ministry confirmed that the policy requirement does not create any new legal right for employees to disconnect from work. The rights of employees to not perform work are established under other ESA rules, such as those pertaining to hours of work, eating periods, vacation with pay, public holidays, etc. The guidance also clarifies that the employer is not required to have the same policy for all of its employees. The employer can have one policy that applies to all employees, or the policy can contain different policies, either in a single document or multiple documents for different groups of employees. So, for example, one practical example might be that executives have a policy including expectations for them, and a different policy would exist for juniors with relative expectations for them. Client-facing employees may have different expectations than administrative employees, for example. Further, these differences can be addressed either in its standalone policy, or it can all be incorporated into a broader handbook. New slide, please. So currently, the only requirements for the disconnecting from work policy are to include the date on which it was prepared and the date any other changes were made. Nothing more is said in the ESA other than that the policy must contain such content as may be prescribed by regulation. And such regulations don't yet exist. Specific provisions addressing how employees are to disconnect from work are also not required. In a press release late last year, Ontario stated that these workplace policies could include, for example, expectations about response time for emails and encouraging employees to turn on out-of-office notifications when they aren't working. Further, the ESA guide provides the following examples of content that could be included. So, for example, the employer's expectations, if any, of employees to read or reply to work-related emails or answer work-related phone calls after their shift is over. The employer's expectations for different situations, for example, based on the time of day of the communication, the subject of the communication, or who is contacting the employee, and the employer's requirements for employees turning on out-of-office notifications and or changing their voicemail messages when they're not scheduled for work. However, if an employer introduces a right to disconnect in its disconnecting from work policy, the employer can establish such a right for its employees as a greater right or benefit than is required under the ESA. So the employer really needs to be careful to strike a balance between fulfilling the obligations under this new legislation and ensuring that they're not creating undue burdens for themselves or unnecessary limitations on when they can ask employees to perform work. The guide also provides information about the administrative aspects of the disconnecting from work policy, including a retention obligation, and employers must retain a copy of every written policy on disconnecting from work for a period of 3 years after the policy is no longer in effect. So at the end of the day, it's largely up to the employer what you want to include in these policies. That said, it's still a legislative requirement to have this policy in place, and failing to do so could expose the company to risks, complaints to the Ministry of Labour, and potentially civil liability as well. Further, because the obligation is included in the ESA, an employee cannot be subject to any kind of reprisal for having asked about the policy or asserted their rights under the policy. Next slide, please. So now we'll turn to the policy on the electronic monitoring of employees. In early 2022, Ontario became the first jurisdiction in Canada to require certain employers to have written electronic monitoring policies. Bill 88, the Working for Workers Act 2022, amended the ESA again to require provincially regulated Ontario employers with 25 or more employees to implement a written policy regarding its electronic monitoring of its employees. And while some other countries have laws in place surrounding workplace surveillance, Ontario is the first Canadian province to pass a law requiring employers to implement written electronic monitoring policies. Qualifying employers have until October 11, just this past Tuesday, to implement this policy. And just like the disconnect from work policy, existing employees must be provided a copy of the policy within 30 calendar days of the policy being prepared. And all new employees must receive a copy of it within 30 calendar days of being hired. Unlike the disconnect from work policy, however, we have a little bit more guidance on the electronic monitoring policies in general. And the Ministry of Labour has also updated their ESA guide with guidance on this policy as well. So first, we know that the government's intended purpose for this new legislation is to require employers to be more transparent about their electronic monitoring. That said, the province has yet to define electronic monitoring of employees or prescribe any further requirements, prohibitions, or exemptions. We do know that electronic monitoring includes all forms of employee monitoring that is done electronically. So, for example, I've listed a few here, such as GPS tracking of delivery vehicles, tracking websites visited during working hours on company-issued computers, key card or fob data to track office entry and exit times, electronic sensors to track how quickly items are scanned at the grocery store checkout, etc. Other examples of electronic monitoring could include any sort of computer monitoring, employee attendance monitoring, location monitoring on a mobile device monitoring, and closed circuit television. Next slide, please. An employer's electronic monitoring policy must set out the following information. First, whether the employer electronically monitors employees at all. Next, if so, the policy must describe how and in what circumstances the employer may electronically monitor the employees. And third, the purpose for which information obtained through the electronic monitoring may then be used by the employer. Despite this, however, the ESA guide states that an employer is not limited to the reasons they include for using the data. The guide makes clear that the new laws do not create any new privacy rights for employees and do not affect or limit the employer's ability to use information obtained through the electronic monitoring of its employees in any way it sees fit. So while on the one hand, the policy needs to be specific and clear, employers can also be reasonably confident that they won't be limited in the use of the data collected by this new policy. Further, the legislation does not actually prohibit any type of electronic monitoring. For example, the ESA amendments, like I said, don't impose a restriction on whether and how employers can use information and data obtained through the electronic monitoring process. And again, it doesn't create a freestanding right of employees to be free from electronic monitoring. The policy also must include the date the policy was prepared, and the date any changes were made to the policy. And again, it must be provided to employees within 30 days of implementation. Next slide, please. It was timely that this legislation was passed during the pandemic, when many employees were working remotely, and while many employers had introduced new electronic monitoring systems to manage their remote workforce. As a result, the ESA guide is clear that the policy must also address any electronic monitoring of employees that occurs irrespective of whether the employee is at the primary workplace. Further, and in apparent recognition of the fact that employees often use their own electronic devices, the guidance also clarifies that the policy must also include electronic monitoring of employees that occurs on equipment not owned or issued by the employer. Many clients so far have asked if existing policies that include language about employees having no expectation of privacy when using company electronics are enough, and generally they're not. The obligations under this new legislation are much broader and generally can't be achieved through broad general statements. Further, in light of the government's stated objective that the policy is meant to promote transparency in the workplace, we recommend being as specific as possible when drafting the policy. Like the disconnecting from work policy, because the requirements for the policy are enshrined in ESA, the new rules only create a minimum standard. An employer can always draft a policy with a greater right or benefit for the employee. That said, when drafting the policy, employers need to be careful not to provide so much information that their data collection becomes ineffective. For example, employers don't need to advise employees that they are monitoring their web history to see if they browse job opportunities, if simply saying that they collect internet search history metadata would be sufficient. At present, an employee's only regress is to complain to the Ministry of Labour that they have not received a copy of the electronic monitoring policy. They can't actually make a complaint to the ministry about the content of the policy or its implementation. Therefore, it appears that so long as the employer provides a copy of their written electronic monitoring policy to employees within the required timeframe, the ministry would not have the ability to investigate or penalize employers for other types of non-compliance. For example, where the employer fails to be transparent and disclose the types of electronic monitoring that they undertake. However, we do expect that there could be risk for claims of bad faith in the civil context if employers are not transparent in their policy, and then seek to rely on the data they obtained when, for example, terminating an employee for cause. Further, an employer could be held liable in the civil context if its electronic monitoring of employees is not reasonable or connected to any business purpose. And as Pam mentioned at the beginning of this webinar, please note that we are already past the deadline of implementation for both of these policies. The deadline for the disconnect from work policy was June 2nd, and the deadline to implement the electronic monitoring policy was just this past Tuesday, October 11th. So if your business needs any assistance in drafting or implementing these policies, we do have prepared a comprehensive and customizable template for both, and we're pleased to make that available for a flat fee. If you're interested, please send us an email and we can set that up. That wraps up my section of the webinar, and I'll pass it over to my colleague, Claire.
Thanks so much, Allison. And good afternoon again to everyone who's joining us from the East, and good morning to those of you joining us from the West Coast. The next section of our webinar series will provide you with an update regarding recent developments in occupational health and safety law in the province of Ontario. In particular, a number of amendments to the Occupational Health and Safety Act were implemented through Bill 88, the Working for Workers Act 2022. We will also cover two recent decisions regarding certain occupational health and safety principles that we think may be of interest to you. Next slide, please. Thanks. Starting with the amendments to the Occupational Health and Safety Act, Bill 88 increased the maximum fines for directors, officers, and individuals under the Occupational Health and Safety Act. In particular, effective July 1st, 2022, the maximum fines for directors and officers of a corporation were increased from $100,000 Canadian to $1.5 million Canadian, while the maximum fines for other individuals were increased from $100,000 Canadian to $500,000 Canadian. Further, the amendments to the Occupational Health and Safety Act introduced a number of aggravating factors that will be considered when determining monetary penalties under the Act. These factors include whether the offense resulted in the death, serious injury, or illness of one or more workers, whether the defendant committed the offense recklessly, whether the defendant disregarded an order of an inspector, whether the defendant was previously convicted of an offense under the Occupational Health and Safety Act or another act, whether the defendant has a record of prior non-compliance with the act or regulations, whether the defendant lacks remorse, whether there is an element of moral blameworthiness to the defendant's conduct, whether the defendant was motivated by a desire to increase revenue or decrease costs while committing the offense, whether the defendant attempted to conceal the commission of the offense from the Ministry of Labour or other public authorities, or failed to cooperate with the Ministry of Labour or other public authorities after committing the offense. In addition, the amendments to the Occupational Health and Safety Act extended the limitation period for initiating a prosecution under the Occupational Health and Safety Act from 1 year to 2 years. Lastly, Bill 88 announced an amendment to the Occupational Health and Safety Act that introduces a requirement for employers to provide naloxone kits or to comply with any other prescribed requirements with respect to providing and maintaining naloxone kits in circumstances where the employer becomes aware or ought reasonably to be aware that there may be a risk of a worker having an opioid overdose at the workplace, where the worker performs work for the employer or where the prescribed circumstances exist. This particular amendment with respect to the naloxone kits will come into force on a day to be named by proclamation of the Lieutenant Governor. Next slide, please. Thanks. Turning to our case law update, the first case that I would like to draw your attention to is the Ontario Ministry of Labour and City of Sudbury decision. For those of you who attended our webinar series yesterday, this may sound a bit familiar to you, as it was one of the cases addressed by my colleague Adrian Miedema. However, I raise this case today as it is one of the few occupational health and safety cases that has reached the Supreme Court of Canada. So for those of you who were not able to join us yesterday, I'll provide you with a brief overview of the case. This case involves an incident where a woman was struck by a road grader that was performing repairs at an intersection in downtown Sudbury. The grader driver was employed by Interpaving Limited, while the City of Sudbury entered a contractual relationship with Interpaving Limited to complete the road repairs on the project. The City of Sudbury also employed a number of inspectors on the project site. The Court of Appeal considered whether the City of Sudbury was an employer in accordance with the definition of the term employer under the Occupational Health and Safety Act. Ultimately, the Court of Appeal determined that the City of Sudbury was an employer for the purposes of the Occupational Health and Safety Act, as the City of Sudbury employed one or more workers at the project site. The court noted that the Occupational Health and Safety Act establishes overlapping responsibilities for health and safety under the Act and contemplates the possibility of multiple employers in a workplace. In this case, the court highlighted that the employees or city inspectors that were directly performing work on the project were employed by City of Sudbury. These employees were present at the project site and were performing a number of tasks. Therefore, although the City of Sudbury was not the direct employer of the employee involved in the accident, the City of Sudbury was an employer on the site for the purposes of the Occupational Health and Safety Act. However, as I mentioned a moment ago, leave of appeal of this decision of the Ontario Court of Appeal was granted to the Supreme Court of Canada, and this appeal was heard yesterday. Therefore, we are very excited to await the release of the reasons for decision of the Supreme Court of Canada and to see where this whole issue arises and ends up in the end once the Supreme Court of Canada weighs in. Next slide, please. Thank you. Lastly, we thought that we would draw your attention to a recent decision of the Ontario Court of Justice in Ontario Ministry of Labour versus Great Lakes Food Company. In this case, the employer, Great Lakes Food Company Limited, owned and operated a fishing boat. During an expedition on behalf of the employer, a worker employed as a lead deckhand went overboard and unfortunately was not recovered safely. At the time of the incident, the crew was wearing winter clothing. However, no one was wearing a life jacket or any other type of flotation device. Life jackets and immersion suits were loaded on the boat and available in an easily accessible manner to any member of the crew. During the Ministry of Labor's investigation following the accident, the Ministry of Labor issued a work order directing the employer to provide suitable protective clothing to people working on the employer's boat and required that equipment be used when cold water conditions existed. In response, the employer purchased floater coats that contain buoyant material to help protect against cold water in the case of immersion, and required workers on board their boat to wear this floater coat while working. Following the investigation, the employer was charged with 2 offenses, including failing as an employer to ensure that every precaution reasonable in the circumstances was taken for the protection of the worker, contrary to Section 25(2)(h) of the Occupational Health and Safety Act. In particular, the Crown alleged that the employer failed to ensure that suitable cold water protective equipment was provided and used. At trial, the Ontario Court of Justice determined that the Crown failed to prove the actus reus of the offense beyond a reasonable doubt. While assessing the evidence before it, the court considered the totality of the circumstances and noted the following facts. The boat of the deck was dry at the time the worker went overboard. The water conditions were perfect for sailing, and there was little to no wind. There was no evidence led by the Crown as to industry standards with respect to what constitutes cold water protective equipment, and there was no evidence that the employer failed to comply with the provisions of any portion of the Occupational Health and Safety Act or regulations with respect to safety equipment or procedures for fishing vessels. Further, the court determined that there was no evidence before the court with respect to what reasonable precautions should have been taken to mitigate against the inherent risk associated with cold water immersion. The court emphasized that employers cannot be held liable for events that are unforeseeable. And in this particular case, the circumstances surrounding the day of the incident led the court to conclude that there was nothing on the ship, in the water, or in the weather conditions that day to explain why that worker might have gone overboard. Lastly, the court reiterated that an employer's post-incident conduct cannot be used as proof of the actus reus of the offense. Instead, post-incident conduct of an employer may only be used to refute any defense of due diligence in the event that the defense of due diligence is raised. Although this case does not change the state of the law, it reiterates a few of the important principles that are relied upon in the context of occupational health and safety litigation. And with that, I'll turn the floor back to Pam to take questions from the audience.
Great. Thank you, Claire, for that thorough and informative case law update. So to kick off Q&A, Allison, question for you. Does the electronic monitoring policy have to include any fob or entry data that's only accessed in the event of a need to verify information, or is it only related to information regularly reviewed or accessed?
Good question. So the expectation would be that it covers, the policy includes everything that the company is doing to monitor its employees electronically. It doesn't speak to there being a limit, like, you know, if you do it once versus if you do it frequently, if you do it once a year versus if you do it every week. There's no indication that that plays any part in determining whether or not it should be included in the policy. Especially in light of the stated objective of the government, that it's to increase transparency in the practices of the employer. Every part of the electronic monitoring of your employees should be in the policy. That said, there isn't any indication as well that there needs to be included a frequency in which you engage in this specific type of electronic monitoring. So there's no requirement to say, we do this once a year, or we do this, once every 6 weeks, or we do this only when the system is triggered by a certain search term or something to that effect. There's no indication that any of that detail needs to be included in your policy, and arguably, putting it in there would create a greater expectation than needs to be in there, unnecessarily limiting the employer's opportunity to properly monitor their employees.
Great, thank you, Allison. Claire, this question's for you. Does the extension of the limitation period under the Occupational Health and Safety Act impact cases where the accident has already occurred?
Thanks, Pam. So the change to the limitation period under the Occupational Health and Safety Act came into effect effective July 1st, 2022. So it's our understanding that therefore it would apply, and it applies to all accidents that happened after July 1st. There's a bit of a gray area with respect to accidents that have already occurred, but the Ministry of Labor has yet to lay charges. However, that being said, once we get some case law to confirm, we understand that it will apply to accidents that occurred after the July 1st date.
Thank you, Claire. And this question is for me. The question is, in certain circumstances, the insurance carrier will not continue LTD benefits post the date of active employment. How does the employer deal with this during the notice period? So, a great question. Common scenario that employers do face. It is a statutory requirement to continue, LTD benefits if the employee is, enrolled in, disability benefits program, and to continue their, participation to the end of the statutory notice period as required by the ESA. And so, many insurers understand that that's a requirement under the ESA in Ontario. Where they start putting their foot down is any period thereafter and during the common law notice period. And so if you're faced with the circumstance where the insurer is saying, no, we're not going to continue it past the statutory notice period and during the reasonable notice period, and this is an employee without an enforceable termination provision, the options would be perhaps getting that full and final release, so putting together a package that is attractive enough to the employee, where they will sign off on that full and final release that will include language that the employee is waiving any rights to bring a claim for loss of disability benefits. The other way to address it that I've seen in practice and in case law, you could try to go seek pricing for alternative insurance carriers who are willing to provide disability benefits coverage from the end of the statutory notice period to the end of the reasonable notice period. Another option that I've seen employers do is offer compensation in the amount of what it would be for the employee to secure replacement disability coverage, and having that rolled in as part of a termination package. All right. The next question is for Allison. Does the disconnecting from work policy mean that we can't contact employees outside of regular working hours?
Great question. So no, the requirement is currently simply to have a disconnect from work policy in place. There's no specific requirements for the policy other than as set out in what I discussed, and specifically, there's no requirement that companies or their managers or supervisors can only contact employees during regular working hours. like I said in my presentation, the ESA guidelines that talk about, hours of work are outside of this specific policy requirement. And so the policy is really quite general. It doesn't, currently, there's no rules around what exactly needs to be in there specifically about when you can or cannot contact employees. When I said earlier on that it's been criticized for being relatively vague and aspirational, and this is one of the places where we see that come into play. It's aspirational in the sense that the government really just wants you to put a policy in place that provides some structure around an employee's ability to turn off work when we're otherwise connected constantly. But again, there's no detail around that. So, notionally, you could say you have a right to disconnect for an hour, and here's that right. But again, that isn't even prescribed in the legislation. So, no, the short answer to that question is no, that's not part of the legislative definition. And I'll just quickly answer one other question I saw come through in the chat because it's easy and I see that we have some time. The question is, if employees submit their vacation requests electronically, should it be included in the electronic monitoring? And that's a great question because employers, as you know, do a lot of sort of tracking of employee conduct and all sorts of performance matters electronically. From the reading of the legislation, I don't think the fact that your employee submits a vacation request electronically rises to the level of electronic monitoring, primarily because your employee is willingly providing that information. It's not coming by virtue of the employer surreptitiously watching the employee and gleaning that information from the data they collect. So where there is give and take from the employee to the employer, and that is done electronically, I don't believe from reading the legislation that would amount to electronic monitoring. And also from a policy perspective, I can't imagine that's the legislative objective here, because so much of modern business is run electronically, and so that's to try to capture all of that in an electronic monitoring policy, I think would dilute what they have said the objective is, which is to create transparency in the employer's monitoring of its employees. So I hope that answers your questions.
Great, thank you, Allison. And another question for me. Disability benefits are replacing loss of income because of disability. In the cases that you discussed, it seemed like the employee would be receiving both wages during the notice period and disability benefits for the notice period and thereafter. Isn't this, are there any offsets? And so, that's a really great question, and there is a whole host of case law around this, whether receipt of disability benefits can be offset from any wrongful dismissal damages. And in Ontario, it seems to turn on whether or not the employee pays any portion of the premium for the LTD benefits. And if the employee does in fact pay some portion of the premium for the LTD benefits, court seems to treat it as, okay, well, the employee is actually paying for private insurance, and so we're not going to treat it necessarily as replacement for loss of income. In that situation, an employee can both collect disability benefits and any wrongful dismissal damages. And we have time for another question for Allison. Are the policies automatically required as soon as your employee count is 25 or more?
So under the legislation and the changes to the ESA, the only date that matters is January 1st when you're counting your employees. So if, January 1st of 2022, you have 24 employees, and then somewhere in the year this year, you hire one more, the obligation to have these policies in place only kicks in as of January 1st of the following year. So if that individual is still employed as of January 1st, 2023, then these obligations would kick in, and you would have 30 days to present to your employees the written policy on both of these pieces.
All right, and we still have time for more questions. This one's another one for you, Allison. Do we anticipate how the disconnecting from work legislation may evolve? We're thinking about global organizations and matrixed reporting structures where Ontario employees report into managers based in different countries and time zones.
So yeah, that's a great question, and it's something absolutely to consider, because this is such unique legislation, specifically for the disconnecting from work policy. Employers who want to implement it in a multi-jurisdictional sense need to be aware of a couple things, I think. First of all, that they're not creating new and onerous obligations in jurisdictions where this isn't required. But also, I do expect we're going to see legislation like this crop up in other jurisdictions, both in Ontario, but outside Ontario as well. It's a global issue, and we know places in Europe have already implemented a right to disconnect from work. And so it's advisable to stay alert to the changes that come into place, wherever your employees work. And certainly, what laws would apply where you have multi-jurisdictional employees reporting to, as you say, supervisors and managers in other jurisdictions. There's a bigger conversation about what laws would specifically apply to those employees, but it's absolutely important to be live to what laws apply to those individuals regarding a right to disconnect from work. And certainly your policy can either be a standalone policy for your individual Ontario employees, or it can be part of a larger, say, global handbook if you have a multi-jurisdictional employee base. So that said, I think we are going to see it evolve. I think we are going to see it in other jurisdictions. And I do expect there to be a little bit more guidance coming through. I mean, we don't have any indication of this, but I do expect that we're going to see a little bit more guidance come through, if not the government, through the courts, as we see this legislation be tested both through the Ministry of Labor, but also through the civil liability and through the Superior Court, where people might seek to rely on it for things like bad faith damages or other issues. So I do expect it will evolve, and I expect we will get more information about exactly how it should be implemented. And I think it's important to stay alive to how it rolls out in other jurisdictions as well.
Great, thank you, Allison. So we are at the top of the hour, and I want to thank our speakers and attendees. Be sure to subscribe to our Employment and Labor blog and Canadian Employment and Labor Law podcast to get the latest updates. Details can be found on our website and will be shared in the post-event email that you will receive next week. And again, for both the Ontario Electronic Monitoring Policy Template and the Disconnecting from Work Policy Template, please feel free to request them from any Dentons Employment team member via the links in the chat or the materials that will be emailed to you following this webinar. Day 3 and the last day of the series will take place at 12 p.m. Eastern Time tomorrow, and we'll cover the latest on employee and contractor misclassification, Accessible Canada Act, and employment contract termination provision tune-up. Be sure to check it out. And last but not least, we are hosting the 36th session of our Legal Update for Canadian Employers webinar series on Friday, October 28th at 12 p.m. Eastern Time. Hope to see you there. Hope to see you tomorrow. Thank you, everyone.